Thank you, Your Honor. 3 points, briefly. First, about the scope of the duties. Second, about the Establishment Clause. Third, about the disclaimer. Judge Nelson, you asked opposing counsel whether there was anything that Coach Kennedy could do on the job that would be protected by the First Amendment. His answer, if I understood it correctly, was basically no. If there's conduct that he engages in that may be incidentally observed by a student, the district's position is that may be proscribed without constitutional protection. That is a radical rule, Your Honor, and it is a radical expansion, or rather an undermining of First Amendment protection for public employees. This court en banc in Dahlia made clear that employers cannot restrict employee rights by creating excessively broad job descriptions. And that's effectively what the district has tried to do here by characterizing Coach Kennedy as a teacher plus. The tremendous irony here, Your Honor, is that they are trying to use his stature in the community to justify a rule that strips him of all constitutional protection. And the rule that they've articulated would equally prohibit a teacher from wearing religious garb or from engaging in any lunchroom prayer that may be observed by students.
Is it your position that Coach Kennedy could, for example, wear priestly robes if he if he belonged to an organization where that was part of his practice? Could he wear priestly robes and go on the field and do the same thing that he did without those robes?
Your Honor, that would be a different case. You would have to look at the nature of the religious conduct, but we do think the clear implication of the district's rule is that a teacher could be fired for wearing a headscarf or for wearing a yarmulke, because that would be expressive activity that would be incidentally observed by students in the course of his duties. Your Honor, if I could turn briefly to the Establishment Clause. There is no Establishment Clause or even a risk of an Establishment Clause violation here. What the reasonable observer would see would be Coach Kennedy kneeling on the field for 15 seconds. The reasonable observer would at most conclude that he's engaged in a personal moment of silence. Under Santa Fe, no reasonable observer would view that act as a state endorsement of religion. And to know that, Your Honor, you can simply look at what the district itself has said here. The district concedes in its papers below that it is without sufficient knowledge to admit or deny whether Coach Kennedy prayed at all in the game for which he was suspended.
Let me ask you something, counsel. The opposing counsel, if I understood correctly, suggested that the court could decide a case based on the second prong of Eng only, without getting to the Establishment Clause, based upon his role, the totality of the circumstances, and basically insubordination in effect. Do you agree with that?
Your Honor, we agree that Eng is a sequential test, so we do have to prevail on both prongs. This court could stop at step 2. On the question of insubordination, though, Your Honor, it's very important to note that the district has abandoned any argument. They've never, in the course of this litigation, made any argument that some dereliction of his duty was the justification for their actions here. They've leaned only on the Establishment Clause. One final point, Your Honor, about in response to Judge Kristen's question about the disclaimer. Your Honor, this court has said expressly in the Hills case that the desirable approach is not for students to throw up their hands. It is far better to teach students about the First Amendment, about the difference between private and public action, about why we tolerate divergent views. The school's proper response is to educate the audience rather than squelch the speaker. Your Honor, we respectfully ask you to reverse.
Thank you. On behalf of the court, we want to thank all counsel. I know some of you are probably acting pro bono. We particularly appreciate that. And we also, if you will, celebrate the rule of law. This is how we resolve serious disputes in a court of law, where people can come and make their arguments without swords, without guns, without knives, and we will resolve this issue based upon the law as we understand it. We respect all of you. We respect the fact that this process is incredibly important for our country, incredibly important for the parties, and we commend the lawyers for the excellent job they have done in their arguments and their briefing, and the court stands adjourned.